Hi everyone, this is Shivani again, and today we're going to learn about the basic concept of the doctrine of judicial review under the Constitution of India. The doctrine of judicial review is basically the power of the judiciary to decide on the constitutional validity of the acts and of other wings of the government, which are the executive and the legislative. The objective is to regulate any act which may contravene the Constitution. For instance, any act of lawmaking bodies is such that it negates the provision given in the Constitution. It is important that it should be made null and void. In order to do so, an organ is required to monitor such force or power that is given to the executive as well as the legislative to turn these acts into void ab initio. This power is given to the judiciary by way of judicial review. This is where the importance of the doctrine of judicial review comes into play. Thus, when the lawmaking bodies are acting in contradiction to the law, the judiciary can then intervene and then decide on the constitutional validity of such act. In one of the most landmark cases that we all know about, which is Keshavananda Bharti versus State of Kerala, Justice Khanna had spoken about the importance of judicial review in today's time. He stated that judicial review has become an important part of our constitution and also said that it has been vested in the High Courts and the Supreme Court to decide the constitutionality of the provisions in different statutes. On the off chance that the provisions of any statutes are observed to be violative of any articles of the Constitution, which is standard for legitimacy of all laws, the High Court and the Supreme Court have the power to strike down those provisions and as well as strike down the entire law. This is what Justice Khanna had stated in the case of Keshavanand Bharti versus State of Kerala. Some of the articles which are relevant to the judicial review in the Constitution of India comes from which are the following, which is the means for judicial review. First of all, it is based in under the main article, which is through which the fundamental rights come into existence, which is Article 13 of the Constitution. It gives the power to the courts to keep the legislation under the preview. The article gives to the judiciary the power to declare an act or law void if it is not in consonance with Part 3 of the Constitution, which is if it is not in consonance with the fundamental rights of the Constitution. Additionally, this Article 226 and Article 226 of the Constitution also aid the judicial review. If a person's fundamental rights have been violated by any legislation, they can may move to the High Court under Article 226 and 227 and to the Supreme Court under Article 32. This power of the High Court and the Supreme Court under Article 226, 227 and 32 respectively of the Constitution was initially it was recognized in one of the most landmark cases, which is Chandra Kumar versus Union of India. Also, in another landmark case, which talked about the power of judicial review after the 42nd Amendment, a case came up, which was Indira Nehru Gandhi versus Raj Narayan and others. The court declared that judicial review is a part of the basic structure of the Indian Constitution. We can state that the power of the basic structure was derived from the case of Keshavanand Bharti versus State of Kerala. However, it was enhanced in the case of Indira Nehru Gandhi versus Raj Narayan and another. So, what is the genesis of the doctrine of judicial review? The doctrine of judicial review, it has evolved over the course of several years. However, it is important to understand that we understand how it has come into being or what the genesis of that doctrine is. First of all, the doctrine of judicial review was first originated in America, which was established through the case of Marbury versus Madison. Through this case, jurists have long been arguing that it is one of the most important cases in American legal history, which is why the scope of judicial review has come into existence or expanded in the state of America. The reason for this is that in the constitutional law, as it was very case, the Supreme Court of United States of America established the doctrine of judicial review. The court set out that federal laws are in contradiction with U.S. Constitution. Federal laws which are in the Constitution, which are in again, contradiction with the United States Constitution would be held invalid, and the ability and the power to decide whether those laws are invalid or valid or unlawful or even void rests with the judiciary. This is alluded as judicial review, and this was the very first case that talked about the concept of judicial review in the United States of America. However, the jurisdictions of the court to judicially review the acts of the legislature as well as the executive, which are in a contradiction to the US Constitution, is not unlimited, which means the judiciary cannot poke its nose into the powers of the executive as well as the legislature on every step. Certain limitations have been set out in the Constitution of the United States, and the facts and the judgments of the case uh, are mentioned, which I'll be telling very soon. So, in the year 1880, there was a person named Thomas Jefferson who had won the presidential race against John Adams. President Jefferson was to come into office on 4th of March 1801. Before President Jefferson came into the office, the active president John Adams and the Congress passed the Judiciary Act of 1801. This gave more control and power to the president in the appointment of judges. It was only basically an endeavor by Adams and his party to baffle President Thomas Jefferson. He utilized the act to choose 60 new circuit judges and 42 new judges for peace. These new appointments were approved by the Senate, yet they could not be said to be valid in their commissions were conveyed by the Secretary of State. William Marbury was one of the appointees approved by the state. However, his commission was not delivered by the Secretary of State. Marbury filed a petition of writ of mandamus in the Supreme Court in order to compel the delivery of the commission. What the court stated, the court held that the powers of Section 13 of Judiciary Act 1789 that gave the courts the power to issue writ of mandamus to an office was in itself in contradiction to the US Constitution. It was held to be unconstitutional and void. This way, the court struck down a provision of the Act which was in contravention to its constitution. Therefore, by virtue of this case itself, the US Constitution had exercised its power of judicial review to strike down the provision which was in contradiction or contravening the provisions of the US Constitution. What is the importance of this doctrine, the doctrine of judicial review? The importance of the doctrine of judicial review is that at the very top, it holds supremacy of the Constitution. It becomes important when it comes to upholding fundamental rights of the individuals. When a constitutionally unjust law is in place, then doctrine of judicial review comes into play and determines the unconstitutionality of such a law. Therefore, it becomes very relevant in the increasing times, considering the world scenario, the present scenario that we have in our country, to give the judiciary this power to conduct a review based on the legislations being passed. It treads on the aspect of checks and balance, which is an important element of democracy, and ensures that neither the government, in terms of its execution or making laws through legislative powers, misuses their powers and maintains the balance of all the organs of the government. In India, we do not follow an entire separation of power like the federal system that USA has. However, we do have a quasi-federal system, which means that even though we follow checks and balances, we keep a check on the other party, other organ of the government, giving hold to one power so that one organ does not interfere with depending upon the fact that one organ does not interfere with the other organ of the government, as well as the other organ can keep a checks on the powers and limit the powers of of the other organ of the government. So, in conclusion, the doctrine of judicial review is extremely important. That in order to ensure that the judiciary is not encroaching over the other organs of the government, it is essential that the judges be coherent, lawful, and moral and people-centric. So, in a developing country like ours, judicial review has gained more importance in the upcoming years, considering the laws and the acts that were made recently. And judicial review is of utmost importance to common people because whose rights are infringed, a lot of common people whose rights are infringed without notice to them. This doctrine gives the power to the judiciary to render an unconstitutional act. It will check on the powers of the legislature as well as the executive so that none of those powers are misused. Taking into consideration that we are evolving as a nation and we moving towards more progressive status, our understanding of constitutionalism and natural justice is also changing. Thus, a social progress is also to be considered while taking into aspect the power of judicial review given to the judiciary through the constitution. Although judicial review remains a highly controversial topic, considering the fact that how far can the judiciary actually go on to limit the powers of the executive and the legislative, or whether it is encroaching the power of the legislative and the executive. In my opinion, judicial review is a very essential tool that the judiciary holds, that the constitution has provided the this body of government. Thank you so much.